Hello, everyone. Welcome to this webinar, Why the African Court on Human and People's Rights Matters. Thank you. We are glad and honored that you are joining us this afternoon for this important discussion that focuses on the African Court on Human and People's Rights. This webinar seeks to raise awareness about the African Court on Human and People's Rights. This is a court that is based in Arusha, Tanzania. It's a continental regional court that seeks to protect human and people's rights across the continent. The webinar is organized by three specific organizations. The Center for Human Rights, which is an academic department at the Faculty of Law at the University of Pretoria, which is also registered as a non-governmental organization. It's a leader in human rights education that involves research, human rights education, and dissemination of publication on human rights on human rights issues. The event is also organized by the African Court Coalition, a non-governmental organization established in 2007, based in Arusha, Tanzania. Its main focus is to promote an effective, independent, and accessible African Court on Human and People's Rights. And the third organizer and partner for this specific event is Amnesty International, which is a human rights movement that is based across Africa and across the world. And our aim is to promote the enjoyment of human rights by all individuals. This afternoon, to really facilitate this discussion, we will have three panelists and myself as a moderator. We will have Meredith Lwanga, who is a senior legal officer at the African Court on Human and People's Rights, and she's also the head of the legal aid unit of the African Court. We also be joined by Sophia Ebi, who is the coordinator of the African Court Coalition, where she leads the execution of the mandate and mission of the African Court Coalition. And then finally, we are also joined by Dr. Zainab Olaitan, who is a postdoctoral fellow at the Center for Human Rights, University of Pretoria. They're going to speak to different aspects of the topic before us today. And then at the latter stage of this event or webinar, we are going to receive questions and comments from you, the public. The main aim of this event really is to raise awareness about the African Court and to ensure that African citizens across the continent are aware of the court, are aware of its existence, and that they can use it to protect and promote their own human rights. But more importantly, that they can also pressure their own governments or demand from their own governments that, one, they ratify the African Court protocol, which establishes the court, if they have not done so. And then two, and perhaps more importantly, that they make a declaration allowing individuals and non-governmental organizations to directly access this court if they have not done so. These are the two major aspects that we are going to talk about this afternoon. But to kick us off before we go to the panelists that are going to speak to these issues, we have a short video that will provide for you a broad overview of what the court is and how you can access it as an African citizen. Now onto the video.
We all have human rights. And no, human rights aren't just a Western ideal. The African Charter on Human and People's Rights recognizes that all individuals and communities have rights. It says that we have the right to life, health, family, equal protection under the law, a fair trial, education, practice religion freely, protest, express ourselves, and so much more. But sometimes our rights are violated and we cannot find any help from the authorities or the tribunals from our countries. So who can we turn to? When our state has failed, the African Court on Human and People's Rights is our last resort for justice and reparations. The African Court was created to protect and promote the rights recognized in the African Charter and other human rights treaties. It is based in Arusha, Tanzania, and is composed of 11 independent and impartial judges drawn from around the continent. When the court receives a human rights complaint against a state, it asks states concerned to respond, studies the case, sometimes conducts a hearing, and decides whether the rights of the plaintiff have been violated or not. In the event that it does find a violation, the court may order the state to stop or remedy the situation. The orders of the court can range from a specific measure to change the situation of one or several persons, all the way to orders that have a broader impact, such as changing the law to prevent further violations. However, the African Court can only receive a complaint if the state we live in has ratified the protocol that has established the court and has made an additional declaration allowing individuals and NGOs to petition the court directly. To date, 33 African states have ratified the protocol, and only 8 of them have deposited the special declaration. 4 other states have also made such declaration, but withdrew it later, taking back from people a crucial judicial recourse that had already been granted to them. It is important that all African Union member states to ratify the protocol establishing the African Court on Human and People's Rights and make the 34-6 declaration allowing direct access to the court by individuals and NGOs. This will ensure that individuals and NGOs can seek justice and reparations in the event that their rights are being violated at home. Human rights for everyone. It's time to protect the African Court so it can continue to protect us.
So that video provides a really broad overview of the African Court, what it does, and what you citizens of African countries can do to access it, or what is required for us to access it. I'm glad to see that we are having people from all over the continent joining the event from Zambia, Zimbabwe, Nigeria, Kenya, Benin, Botswana, South Africa, Namibia, Lesotho. So the aim of this really is to reach to as many African citizens as possible and to raise awareness about the court. And following that short video, I'm now going to invite our first panelist, Meredith Lwanga from the African Court on Human and People's Rights, to speak to us on what the African Court has been doing to ensure that we have universal ratification of the African Court protocol that establishes the court, and also what it has been doing to ensure that as all the countries that have ratified that protocol are able also to make the declaration that will allow individuals and non-governmental organizations to directly access the court. Meredith Lwanga, over to you.
Thank you very much, Japhet. Good morning, good afternoon, good evening to all the participants. My name is Meredith, and I'm going to go straight to the 2 questions that were put to me, specifically what the court is doing to encourage the universal ratification of the protocol and deposit of the declaration. And then I'll shed some highlights on some of the state reactions to the work that the court has been doing in this regard. So as the video portrayed, since its establishment, 21 AU member states out of 55 have still not accepted the court's jurisdiction. Additionally, 26 state parties to the protocol out of the 34 have still not deposited Article 34.6 of the declaration allowing direct access to the court, while 5 states have withdrawn their declarations. The 5 states are Rwanda, Benin, Tanzania, and Cote d'Ivoire. So the court had projected within its strategic plan of 2020 to 2025 that at least we'd have an increase of 15% more of AU member states that have ratified the protocol. That would have made a total of 71 or at least 38 countries. Additionally, it had also projected that we would have at least 15 more AU member states that have deposited Article 34.6 of the Declaration, making a total of 26 out of, or rather 14 countries. So we still have a long way to go, and we still have one more year to reach this target. So what the court has been doing in this regard is it's devised various mechanisms to encourage the member states to ratify the protocol. One of the mechanisms is during its engagement with member states and other stakeholders, it engages the states on how the work of the court is actually, the procedures of the court. It notifies the states that it strictly adheres to its rules of procedure and the African Charter and the protocol, because there's a profound fear by the member states that if they ratify the protocol and deposit the declaration permitting direct access to the citizens, then there would be an avalanche of cases filed before the court. So one of the ways that the court has tried to mitigate this is to actually notify the states that it follows a strict criteria on by considering the jurisdiction and the admissibility criteria, including the very crucial condition on the exhaustion of local remedies. Furthermore, the decisions of the court are reached after conducting in-depth research, deliberations, and by applying well-reasoned principles in compliance with international human rights standards. So that is one of the ways that the court has tried to assure the member states that really there would be no harm in ratifying the protocol or depositing the declaration. Another is conducting outreach and sensitization missions, which are principally focused on, they're basically geared towards obtaining additional protocols and ratification and disseminating the work of the court. These missions also provide a better understanding of the court, of the local context in relation to the court and of the country, and vice versa. So to date, as has been expounded in the video, there are to date, the court has conducted more than 35 sensitization missions on the African continent. And typically these missions include engagement with government officials, which include the president as well. They include a seminar or a workshop, and this is where all different stakeholders are invited. And they include engagement with the media. This is also usually in form of a workshop and a lecture at one of the main universities in the country. So since 2020, 3 more ratifications were made, and these were by Madagascar and the Democratic Republic of Congo, as well as Zambia. So the court would like to attribute this to the sensitization missions that it has conducted. And another initiative that the court employs is judicial diplomacy. Here the court continues to engage the member states through either the Permanent Representatives Committee, which is a composition of the ambassadors on the ratification. They try to engage the states to find out what obstacles are preventing the states from ratification and deposit, and basically sustaining rapport to enable these countries to come on board. Another is through the court has negotiated with the member states to appoint national focal points, who are national focal points for the court, who foster cooperation on activities pertaining to the court's work. This includes engagement with various ministries and national and regional courts. And it's the hope of the court that these focal points can also be used to follow up not only on the implementation of the decisions of the court, but to also advocate for the ratification of the protocol and deposit of the declaration. And now maybe I would like to share some of the reactions. I captured the reactions that the court has received from 13 countries that have been visited from 2001 to 2024, well, up to date. And so the countries that have been visited include Ethiopia, Niger, Guinea-Bissau, Kenya, Algeria, Mauritania, Benin, Zambia, Tanzania, Mozambique, Sao Tome and Principe, Cape Verde, and Liberia. So, as I said, when the court conducts the sensitization missions, they meet with the various authorities, including the president, the Ministry of Foreign Affairs, and all other stakeholders that are involved in the process of the ratification and deposit of declaration process. So now the reactions I'm sharing are from the Office of the President. So from Ethiopia and Mauritania, the court delegation undertook the visit to encourage these two countries to ratify the protocol because they hadn't yet ratified, as well as depositing the declaration. In this regard, both countries indicated that they were actively considering ratifying the protocol. The court also signed an MOU of cooperation with the Supreme Court of Ethiopia because the court looks for different stakeholders to engage with to enable it to implement its functions. So now when it came to Zambia, Zambia actually signed, following the court's visit, Zambia signed the protocol establishing the court. I've seen we have representatives from Zambia online, so that's a good thing. If you could encourage your states to deposit the declaration as well, this would be good because it would allow you direct access to the court. And then we have Niger and Guinea-Bissau. These went ahead and deposited Article 36 of the declaration, allowing direct access to the court by the citizens. So that was, these were very fruitful visits. I think these were the most successful that the court had last year. So when it came to Kenya, the court visited in July 2023. The African court president encouraged Kenya, which had already ratified the protocol, to consider depositing the declaration. And she also called upon the Kenyan authorities to take urgent steps to implement the court's judgment in the matter of the African Commission on Human and People's Rights versus the Republic of Kenya. In this regard, the Office of the President undertook to consider the requests made by the court and expressed willingness to engage all relevant stakeholders to see how best to implement the judgment. I have also seen representatives from Kenya, so with this information, perhaps those who are engaged in this process can follow up with the authorities that have the power to deposit the declaration. And then when it came to Mozambique, the court also visited in August 2023. In this regard, the president of Mozambique intimated that most of the states, actually he shared with the delegation that most of the states are hesitant about interacting with international jurisdiction. However, in his view, the human rights situation in Mozambique was not a cause for concern. He did point out that there were some acts of terrorism in the northern part of the country where NGOs reported significant recruitment of children into the military ranks. He, however, undertook together with the authorities to consult with all the relevant stakeholders before deciding on the deposit of the declaration. When it came to Sao Tome, the court visited again in August 2023. In this regard, the court had undertaken the visit to encourage the country to ratify both the protocol and to deposit the declaration. Here, the president assured the court delegation that the authorities would undertake further consultation with all relevant stakeholders in the country in order to decide on the ratification of the protocol and deposit of the declaration. Furthermore, he noted that the issue of ratification of the court's protocol was in progress as it was scheduled for consideration during the next session of the Assembly of the Republic, and which was due to commence mid-November last year in 2023. He therefore assured the court that these procedures were on track. When it came to Cape Verde, the court visited again also in October 2023. The court undertook a visit with the same intent, and the president noted that he had actually visited the court. I beg your pardon. The court noted that the president noted that the Carter's visit was undoubtedly a continuation of a former visit that the court had undertaken in 2017. He also recalled that he had visited the court seat when he was the prime minister, and at the time had appreciated the work of the court. He also observed that Cape Verde would examine the request to ratify the protocol, and further that consultations would take place amongst the political parties represented in parliament, including consultation with stakeholders and who are involved in this process. Algeria, I'm winding up. I have 2 more to go. Algeria was also visited in November 2023 by the court. And here the president and the authorities assured the court that the government would consider the request in due course. When it finally came to Liberia, the president of Liberia noted that the court delegation had already visited his country in 2018, and he observed that on that particular occasion, during that period, it wasn't possible for Liberia to ratify the protocol, but that by April 2024, the Liberian government had welcomed the opportunity to reassess the matter, and that was also on track. So these are basically the reactions that we've received from the states when it came to the court visiting them and urging them to ratify the protocol and to deposit the declaration. And as I said before, the court went ahead and signed MOUs with the Supreme Courts of Sao Tome, Mozambique, and Cape Verde on the sidelines of the 6th African Union Judicial Dialogue, which took place in Algeria in November 2023. So yes, in a nutshell, this is what the court has been doing. Perhaps I will respond to the other questions because I was only given 5 to 7 minutes. So I will leave it at this. Thank you, Japheth.
So I'll take over from Japheth. Looks like it dropped. Thank you, Meredith, for your presentation. Sophia, can you begin your presentation? Thank you.
Okay. Mira, can you please share the screen of my presentation? All right. Thank you very much, everyone. First of all, thanks to all of you who have been able to join us here. And of course, given the limited minutes that I have, I'm going to delve in right away to my presentation. Okay, I would also like to thank the previous speaker, Meredith, for giving us at least that the background of what the court has been doing, the efforts to increase the ratification of the African Court Protocol and direct access to the African Court. We, as the African Coalition, first for the advantage of those who do not know about the African Court Coalition, we are an NGO, independent NGO, but we work towards advocacy to create an independent, accessible, and effective African Court on Human and People's Rights, and we are based in Arusha, Tanzania. And part of the activities that we've been doing, of course, one is advocacies to increase ratification of the African Court Protocol, but also direct access to the African Court. And I know the audience that we have here, I know not all of them are lawyers or not all of them are civil society organizations. I'm sure we also have the non-lawyers here and those who do not work for the civil society organization, because most of the time you have this perception that, the African Court, it's there for the lawyers or civil society organizations. But I think it's very important for all of us to understand why the African Court is important for all of us, being lawyers or not lawyers. And I will begin my presentation. Mira, if you can go to the next slide, please. Of course, Meredith has already introduced the African Court, what it is, and why was it established. And looking at the jurisdiction of the court, there's contentious jurisdiction, of which it has jurisdiction to deal with all the cases and disputes submitted to it in regarding to the interpretation and application of the Charter, the Protocol, and other relevant human rights instruments. But it also has advisory jurisdiction, of which application can just be filed to the African Court to seek this advisory for the qualified NGOs, because there are criteria for NGOs to file application for advisory jurisdiction. And now on to the next slide, because we should basically ask ourselves, yes, we should ask ourselves, why should everyone care? Because we first need to establish this so that you don't only think this is only for the lawyers and civil society organizations. And to look at this, I've just decided, of course, there are so many reasons why we should care, but right now, let us for a bit just reflect on two important themes for this year. One is the African Union theme of the year 2024, which reads there. It says, educate an African fit for the 21st century, building resilient education system for increased access to inclusive, lifelong, quality and relevant learning in Africa. But also the theme for the African Court for this year, it says enhancing the justiciability of economic, social and cultural rights, with an emphasis again on the right to education. And then on the next slide, now let us look in its generality. What are the examples of economic, social and cultural rights? The economic, social and cultural rights, of course, they include the right to adequate food, right to adequate housing, right to the right to education, to health, to social security, water, sanitation, right to work, the right to take part in cultural rights, etc., etc. And now, if we have to look at the obligations now of the states, they do have a duty to respect, to protect, and fulfill economic, social, and cultural rights. They are required to progressively achieve full realization of these rights over a period of time. And regardless of resource availability, they can have an obligation to take appropriate steps to ensure continuous and sustained improvement of these rights over time. Now, looking at all of these rights that I have highlighted, please go to the next slide, please. So my question to all of you, if you look at all of these rights, can you really detach yourself from this? Most likely the answer is no. And if the answer is indeed no, then you should care about the African Court, because it actually does have jurisdiction to interpret these matters in accordance to the African Charter, but also all the other relevant human rights instruments that a particular country has ratified. Because in most cases, the governments or we as citizens, we've just been thinking of human rights as being, detached from our everyday life, which is not the case. And our governments, of course, most of them are doing what they need to do to provide us with this very important rights to us. But also when, they have taken, say, too much time to realize this. And then we've tried so many efforts, and then they have not worked. What we can do, we can actually approach or engage with the African Court and other African human rights mechanisms to address these issues. So this is why we say that everyone should actually care about the African Court and why it needs to be effective, why it needs to be accessible, and why all of us should actually have access to this particular institution. But of course, there are also other rights, like civil and political rights. But of course, today I'm not going to dwell on this one. I just wanted to focus on the social, cultural, and economic rights, because these are the rights that, like most of us think that, we can just struggle. But then again, we do have these mechanisms that we can use to address this if our governments have not taken reasonable steps to realize this particular rights for us. And now I am going to go to how all of you or all of us can you actually be part of the process to make the African Court more effective and accessible. How you can do this, please go to the next slide, please. Yes, so we do have the civil society organizations or legal practitioners who have direct access. And when I say who have direct access, it means the ones who are based in the 6 countries. No, is it 6? Is it, I think it's 8 by now. 8 countries that have direct access to the African Court. So if you are a civil society organization or a legal practitioner in those particular countries, then you can file strategic litigation on various issues. You can monitor and follow up on implementation process at national level. And my colleague Zainab is going to talk more about implementation. But you can also, where the court has rendered judgments and then there's no implementation, you can also request for compliance hearings at the African Court. But also, you as a civil society organization and legal practitioners, for those ones who do not have direct access to the African Court, you can still engage with the African Court in different ways. You can do that through advocacy work at national and regional level. You can issue press releases, statements, and policy brief on why your government should ratify the African Court Protocol and or deposit Article 34.6 Declaration of the African Court. You can also engage with the media. You can provide public education on the importance of the African Court to the African citizens. But you can also, for those ones who engage with the African Commission, when you file your submissions, you can actually request the African Commission to refer the cases that you've submitted to the African Court, and this is allowed under Rule 130 of the 2020 rules of the African Commission. But you can also file requests for advisory opinion for qualified civil society organizations, of course. You can also submit amicus briefs with other civil society organizations that have access to the African Court, but you can also join the legal aid scheme of the African Court. And Meredith here is actually the head of the legal aid scheme, and I think maybe later on in the questions she can talk more about this one. But also for the academia, the students, the researchers, they can also enhance effectiveness of the African Court through inclusion of curriculums and modules about the African Court, the African human rights systems in education institutions. They can take part in annual African Human Rights Yearbook that is published jointly by the African Court, the Commission, and the Committee. You can publish independent articles about the work of the African Court. You can also participate in debates and moot courts on the African Court. You can also provide commentaries on the judgments of the African Court with the aim to garner critical propositions to improve case laws. And finally, for the African citizens in general, what you can do, you can still engage with your governments through your relevant constituencies and other relevant national platforms and ask why if you are in a country that have not yet ratified or deposited Article 34.6 declaration, ask them why you still do not have access to the African Court. But you can also participate in public discussions. You can sign petitions. Also, please be on the lookout for the information about the African Court and the African human rights system in general. And finally, you can join the African Court Coalition, because we are a member-based organization, and if you join us, it means we join our hands together and then we amplify our voices to make the African Court much more effective. So we all, I say human rights is our collective responsibility. Let all of us play a role in creating the African human rights institutions that are effective, independent, and accessible. And finally, by concluding, in most cases than not, and for us who have been doing the advocacy work, we've actually noticed this reaction from the state actors or from the leaders of our governments, thinking that these courts, like they are after them and then restricting access. But we have also seen cases where these leaders are there and then they have not created conducive environment for human rights by ratifying these protocols or giving direct access. And then when they are no longer in power and then they feel they are victims, they want to access this court, but they did not provide that access. So living, at that juncture, of course, I will throw it to Japhet. He is the moderator, but he also has a role, to give the points as well. So maybe he can pick it up from there, speaking about why our leaders, our African leaders, really need to ratify and give direct access to the African Court. So to this juncture, I say thank you very much. Asanteni-san.
That you may want to focus on, in addition to your presentation. Someone from the watching this event is asking, are the judgments of the court binding? And I think that is related to the question of implementation that you are dealing with. Over to you, Zainab.
Thank you so much, Japhet. My name is Zainab Munizola Laiton. I work at the Center for Human Rights. We are both an academic department in the Faculty of Law and also an NGO. And we work mostly with strengthening the capacity of the African human rights bodies, the courts, the commission. So I'll be touching on some of the issues. I mean, the previous speakers have spoken, Meredith has spoken about what the court is doing to strengthen its capacity, and Sophia has really talked about why we need to care about the court. So I would actually be talking about the issues around the effectiveness and relevance of the court. Now, we've heard that the court acts as the primary judicial body on the continent responsible for adjudicating disputes whose decisions are binding. Now, in terms of access to the court, Article 5 of the Court Protocol grants access to 3 entities: the African Commission, state party to the African Court Protocol, and African Intergovernmental Organizations. Now, this approach restricted access to the court, thereby hindering the court's effectiveness to safeguard human rights. To rectify this, the African Union Assembly made a decision to empower individuals to directly access and submit petitions to the court. However, this is subject to the individual being a citizen of a member state that has deposited a declaration under Article 34.6 of the Court Protocol. And I'm sure you've heard the previous speaker talk about the declaration. To accept the court's competence to receive such cases. This means that if your state has not made such a declaration, you will not be able to access the court. Now, when we engage the issues affecting the court, we find that the court faces 4 unique problems. So 1, we look at the problem of the non-ratification of the African Court Protocol by about 20 states, which Meredith and Sophia alluded to. We also look at the second problem of the failure of a majority of African states to make the declaration under Article 34.6. Currently, only states have made that declaration. We have Burkina Faso, we have Ghana, Malawi, Niger, Mali, Tunisia, the Gambia, and Guinea-Bissau. The third problem now is the fact that of the withdrawal of the Article 34.6 declaration by 4 states. So we have Rwanda, them withdrawing its declaration, 2016, Tanzania, 2019, Benin, and Cote d'Ivoire in 2020. Now, the withdrawal of the declaration is not just bad because it limits access to the court. It sets a very dangerous precedent for other states in the future, a precedent of confrontation and contestation instead of dialogue. It undermines the African court's role on the continent and sends wrong signals about the court and disincentivizes other African states that are yet to make the declaration. And the fourth problem, which is very important, is the failure of states to file reports on the status of implementation of decisions of the court. Now, the statistics of state ratification and adherence to the court protocol does not portray the court as one that enjoys the cooperation and unalloyed support of African states. So we look at from 9 June 1998, when the protocol was adopted, to 25 January 2004, when it finally entered into force. It took nearly 6 years for the court to garner 15 ratifications required for it to enter into force. And as of June 2024, more than 20 years after the protocol entered into force, only an additional 90 states have ratified that protocol. Now, when we now trace how we use the court, first we look at the issue of interstate communication, which is one of the ways you can access the court. Interstate communication is a rarity in the African human rights landscape, oftentimes because of this culture of non-interference in the general, in the domestic affairs of other states, and the idea of brotherly solidarity among African leaders. Now, we also look at between 2006, when the court began its operation, and February 2024, the court has dealt with about 340 applications in contentious matters and 15 requests for advisory opinion. It has also disposed of 205 applications and 15 requests for advisory opinion, with 135 applications still awaiting resolution. The database on the court website as of 9 of June 2024 showed that the court has rendered a total of 390 decisions, comprising 235 judgments and 163 orders. Those figures change from time to time as the court renders new decisions and issues new orders. Now, out of the over 100 judgments that the African court has ordered, the court reported that only Burkina Faso, as of December 2020, has complied fully with its judgment. Tanzania has complied partially with some of the judgments and orders, while Cote d'Ivoire filed a compliance report, but the applicants dispute the fact. Also, the 2023 activity report of the court contains information on the status of implementation of 55 judgments that the court has ordered against member states of the protocol. None of the orders contained in the 55 judgments reported in the activity report have been fully complied with. Some states indicated openly that they will not comply with the orders and judgment on the court in what would appear to be a clear violation of Article 30 of the court's protocol. To put it mildly, the African court is facing not only an implementation problem, but also a problem of legitimacy and cooperation from state parties, which is affecting the implementation of decisions. Because if we believe that the court is important, why are we not complying with the decisions that it makes? Now, the court has alluded to the lack of cooperation by states when it stated that one of the major challenges facing the court at the moment is the perceived lack of cooperation from member states of the African Union in relation to the poor level of compliance with the decision of the court. While non-compliance is not exclusive to the court's decision, a major limitation also has been the court's inaccessibility to individuals who are often victims of human rights abuses. Remember the Article 34.6 declaration that I mentioned earlier. The fact that majority of African states have not deposited this declaration means that most African citizens do not have access to the court directly. Although there's a limited number of states that have made the declaration, the court has been able to receive numerous submissions from various parties. Now, the problem is, the implementation of these decisions still falls on member states, mostly because the court itself lacks the power to enforce its decisions directly and instead reports compliance status to the African Union Assembly, which then adopts measures accordingly. Now, this process has led to a high level of non-compliance, partly because the AU Assembly itself is a political body and can be influenced by political interest. So we have a court that is meant to make binding judicial decisions, still having to report to a political body on the implementation of its decision and relying on that body to implement its decision for it. Now, in recognition of the need to promote compliance with the court's decision, the Executive Council of the African Union requested that the court draft a monitoring and evaluation mechanism that would alert AU policy organs of instances of non-compliance. Now, the proposed framework for monitoring and reporting the execution of judgment provides for the establishment of a formal implementation, monitoring, and reporting unit within the court's registry. This unit would have the specific task of monitoring and reporting on the implementation of the court's decision. It will also have an active role in following up with parties on the implementation of decisions. Now, we as a center, when we look at the implementation of the court's decision, we have, as part of our effort to strengthen the capacity of the court, the Center for Human Rights has organized a series of activities to, aimed at increasing the ratification of the court protocol and also enhancing the implementation of decisions of the African Court. In October 2023, in collaboration with the African Court Coalition, we organized a stakeholder dialogue on the sideline of the commission session then on the need for states to deposit the Article 34 seats declaration and also ratify the court protocol. And then recently in June 2024, in collaboration with the court and the coalition, we organized a conference on the implementation and the impact of decisions of the African Court. We have also organized a series of case discussion focusing on specific decisions of the court to raise awareness. Because like Sophia said, we all need to care about the court and enjoin our African state to also care about the court through their actions. We can't have states not complying with decisions of the court and then complaining that the court is not effective. In conclusion, with the limited number of states that have made the Article 34 seat declaration, the withdrawals of declarations by some states, the non-compliance of decision, we need to make concerted effort to enhance the implementation of decisions of the court in order to strengthen its capacities to safeguard human rights on the African continent. And I'll rest my case. Thank you.
Thank you so much, Zainab, for that very comprehensive tour de force of the implementation landscape in terms of what governments are doing to implement the judgments and decisions of the African Court. And right from the beginning, as Meredith said, and listed the countries that have promised to either ratify the African Court Protocol or to make the declaration that will allow individuals and civil society to directly access the African Court. It is very clear that citizens and civil society have a role to play in promoting or disseminating or demanding from their governments that they need to ratify the court protocol if they have not done so, or that they make the declaration that will allow their citizens. And there are also, in certain instances, specific countries that perhaps should be already have made the declaration. Consider, for instance, South Africa. South Africa is one of the countries that hosted the negotiations during the drafting of the African Court Protocol in Cape Town. It has sent judges to the African Court, and it has a current judge, for instance, at the African Court. It has shown at the global stage that it is a leader on matters of international justice. While it ratified this treaty establishing the court 22 years ago in 2002, it has not made that declaration. So countries like South Africa, for instance, it's time that they actually make that declaration that will allow access to the African Court. And there is a range of so many other countries out of the 34 that have ratified the treaty that have not made that declaration, including, for instance, Kenya, that have ratified the treaty, but they have not made that declaration. This is the plea that this panel is making to these specific countries that have ratified the treaty, but have not made the declaration to do so urgently. As we've now done with our panelists, I would like to invite us to post any questions that we might have on the respective platforms that we are on, and these questions will be collected and our panelists will be able to answer those questions. And perhaps just to begin, for you, Meredith, there is someone who is asking, how is the court financed? How does the court get its resources for it to be able to operate effectively? Meredith. We may need to unmute Meredith. Okay, Meredith, please go on.
Can you hear me now?
Yes.
Okay, yeah, so thank you. No, I was saying that, thank you for the question. The court is financed through contributions from member states, just like any other AU organ. The funding, they as you know, times are hard. They keep cutting the funding, but essentially, the court's judicial operations are financed by the member states. However, there are other activities, including outreach, dialogues, and workshops and meetings these are funded through partner states. Aid development partners. So the court engages various aid development partners, including the UN, including GIZ, and others, to provide funding on issues of mutual interest. It is, however, important to note that in 2018, the the member states had directed the court not to receive any more funding from aid development partners. In fact, they undertook to fund the activities of the court 100%, but this has not happened. And so because there are gaps and there's need for the court to implement its work, it has continued to engage with the various partners to undertake its non-judicial functions. So yes, in a nutshell, that's the response. Thank you.
Thank you so much, Meredith. When we are still with you, Meredith, someone from South Sudan is asking, when would perhaps the court make a sensitization visit to South Sudan? South Sudan, as you know, has not ratified the African Court Protocol. It's one of those 21 countries that has not ratified the court protocol. So I'm throwing the question over to you, but also asking this participant that what we hope is that there will also be pressure from below, pressure from citizens by undertaking activities at the domestic level that will tell the government the importance and relevance of ratifying the treaty. But Meredith, perhaps this is another question for you.
Okay, so the court will visit South Sudan when South Sudan invites the court to do so. So because the way sensitization visits are held is that at the beginning of each year, the court sends out requests to all the 55 member states to conduct sensitization missions. And of course, because of security, because of sovereignty and all that, the court cannot visit without the member states actually accepting the visit from the delegation. So whichever country accepts the invitation of the court, that's the one that the court usually visits, funds permitting. So I know for sure that in 2023, 2 not verbals, a not verbal was sent to South Sudan, including, I believe, 2 reminders for the court to hold a sensitization mission. I know that South Sudan did not formally accept the invitation of the court, but there were informal discussions, so sort of leading to an acceptance, but this did not materialize. So in a nutshell, if the court, if South Sudan accepts the court's invitation or simply invites the court to visit, then the court would not have a problem with in conducting the sensitization mission, funds permitting. Yes, thank you.
Aliu Famara from Gambia is asking whether Gambia has ratified the African Court Protocol or whether it has also made the declaration. I'm pleased to say to you, Aliu, that yes, Gambia has ratified the African Court Protocol, and it is among the 8 states that have also made the declaration. This means that for you, Aliu, and other citizens of the Gambian, of Gambia and civil society of Gambia, this means that you can actually access the court directly, of course, subject to other requirements of admissibility that is applicable to cases that go to regional or international courts. But directly to your question whether Gambia has ratified the treaty, yes, it has. Has it made the declaration? Yes, it has. There is also a question from Zacchaeus Maganga from Kenya, who is asking, what can Kenyans do to ensure that Kenya makes the declaration? As Meredith already said, that during their visit, their sensitization visit to Kenya in July of last year, the government did promise to consider the matter and take it under consideration. So it falls upon now Kenyan civil society and Kenyan citizens to demand from the government that they actually make this declaration, because we have already accepted jurisdiction of the court by ratifying the court protocol. This would, for instance, include engaging with your member of parliament and ask them to ask this question in parliament: when is Kenya expecting to make the declaration and allow Kenyan citizens and civil society to directly access the court? Sophia or Zainab, there is a question that perhaps one of you may want to take. Can the court adjudicate children's rights? Does it have jurisdiction over children's rights issues, or more broadly over the African Charter on the Rights and Welfare of the Child? Sophia or Zainab, either of you.
Thank you, Japhet. I'll go respond to that. Yes, the court can actually do that. It does have jurisdiction to interpret any instruments that relate to children's rights. So the answer is yes. But I would also like to say, of course, there's also the committee, the African Committee of Experts on the Rights and Welfare of the Child, which is specifically responsible to deal with the interpretation when it comes to children's rights and issues to do with children in Africa. And right now, what we are doing as civil society organization, but I know even the committee itself is doing, we want to see the complementarity. Of course, there is complementarity between the committee and the court, but right now the committee itself does not have access to refer cases to the African court. And when that happens, it will make it much more easier, because this will also be another avenue for the cases that have been filed before the committee to be referred to the African court. So that is something that we would really want to see, that complementarity for the committee to have access to file cases before the African court.
Just to add to what Zainab has said, that yes, the court has jurisdiction and can determine or adjudicate children's rights. And actually, in one case against Mali, the African court actually dealt with the issue of child marriage, the minimum age for marriage before Mali, under its family code, provided that girls could be married under the age of at the age of 16. And actually that at the age of 15, they could be married with the consent of the father. And the African court did say and issued a judgment saying that the family code of Mali violates the African Charter on the Rights and Welfare of the Child, because it has not set the minimum age of marriage to be 18. So yes, it does. And there is actually now the practice and jurisprudence from the African court clearly showing that it can adjudicate over children's rights issues. Zainab, to you now, someone is asking a question. Why don't African states consider the court to be relevant? I think an aspect that you touched on. Do they consider it to be relevant? If not, why do they take this kind of position or posture?
I mean, I think it's the issue of when you do something wrong, you'd be scared of whatever mechanisms they had to hold you accountable. So, for example, if African states do believe that the court is important and they believe in the mandate of the court, the way they can do that is for all 55 member states to ratify the court protocol. And if they do believe in the human rights of their citizens, then they should all deposit the Article 34 declaration. However, what we are saying is that a lot of African states are withholding individual access to the court, even though they are claiming they care about the court. And I think we need to then broaden this discussion to the larger African Union space. Oftentimes we see issues about why is the African Union not effective, why are African states not complying with decisions that are being made within this intergovernmental organization. I think it's because most African states are culpable in whatever accusations that they are guilty of. So like we see in Nigeria, for example, we see in Kenya, where governments are clamping down on the right of citizens to assemble and to protest, which is a fundamental human right. So for example, if a Kenyan citizen then want to take that case before the African court, they will be unable to, because Kenya has not made the declaration depositing the declaration on Article 34.6. So I think generally African states try to, in principle, show that they believe in promoting, protecting, and fulfilling human rights. However, their actions don't match their words. And we, as citizens of African states, we need to start urging our countries to actually show their actions. If you care about the court, then deposit the declaration so your citizens can access the court. So I think it's a much more political issue rather than specific to human rights. African states generally try to shield themselves away from consequences and accountability. Thank you, Japhet.
Thank you, Zainab. Perhaps this question, I'll address it to Sophia. Sikombe Amon is asking, has Tanzania made the declaration?
Okay, thank you, Japhet, and thank you for the person who asked that question. Okay, so the answer is yes and no, because Tanzania at one point had deposited the Article 34.6 declaration allowing direct access to the African court. And later on in 2019? Was it in 2019, I think, it actually withdrew that direct access. So it withdrew that declaration, and then from there on, Tanzanian citizens and NGOs with observer status before the African Commission can not file cases direct to the African court. So this is why I say the answer is yes and no. So at one point, yes, and then currently, no, it has withdrew from that particular declaration. And for us, as the African Court Coalition, of course, we've been engaging with state actors, for them to see the importance of having the citizens of Tanzania to have direct access to the African court, because we are also of the opinion, because of course, apart from my capacity as the coordinator of the African Court Coalition, I am also a Tanzanian citizen. Like my question as a Tanzanian citizen will be, like, why is my country hosting this institution and then again not allowing direct access for citizens? And it is hosting the court, with taxpayers' money, and then at the same time not giving us direct access to the African court. So we have been engaging, we have been creating this awareness, engaging with government actors, but we would also like to call upon other actors as well, civil society, legal practitioners, but also the general public in Tanzania and outside Tanzania to talk about these things so that our government sees the importance of providing access to the African court. Thank you, Japhet. Is Japhet there? I think there's...
I think Japhet. So I would take over. Thank you, Sophia, for engaging Tanzania and withdrawal of the declaration. And I think it's important that as much as we are also clamoring for like states to deposit the declaration and states to ratify, we also need to engage states that are withdrawing the declaration after they have been made, and the repercussion that would have for other states that are yet to, and looking at, okay, for example, why did Rwanda withdraw its declaration, and why did Tanzania withdraw its declaration? And Japhet is back, so I'll hand over to him again. Thank you. Japhet, I think you're muted.
Zainabu, in the meantime, could I add a bit of information to...
Okay.
May I?
Yes, you can, Meredith.
Thank you, Zainabu. No, I just wanted to add some additional information regarding the fact that citizens could still access, get recourse for violation of human rights through the African Commission on Human and People's Rights, which is also known as the Banjul Commission. So although Article 34.6 bars direct access to NGOs, individuals, if the state has not deposited the declaration, citizens could still access the Banjul Commission to file their complaints on human rights that have been violated, because we have the complementarity function. The court was essentially set up to enhance or to support the commission in its protective function. So we work together. In this regard, the commission can choose to transmit the complaint to the court, or it may decide to deal with it on its own. So it wouldn't exactly be the end of the world. Even if one cannot access the court, they could still do so through the Banjul Commission. So that's just some piece of information that I wanted to add. Thank you.
Thank you, Meredith. Can I be heard now?
Yes, I can hear you.
Thank you, Meredith. Before you go, there is a participant who is asking, what are the languages of the court, and does it include African languages? And we are slightly over time, so I just need us to spend the next 5 minutes to wrap up with any questions that have come in before we finally conclude the event. Meredith, what are the languages of the court?
Okay, so anyone, all the African languages, anyone can file an application in any of the African languages of the court. Sorry, in any African language, because we have a language unit that can deal with issues of translation and interpretation. However, the official working languages are English, French, Portuguese, Spanish, Kiswahili, and Arabic. So those are the official languages, but you can still file your application in any of the languages. It's just that it makes it easier if you file in any one of those 6 languages. Thank you.
Thank you, Meredith. There was also Jameson McCullough from South Africa was asking, how can we pressure the South African government to make the declaration? As we said before, there are various tools. If you belong to civil society, you can come up with a promotional campaign. If you're a citizen, you can ask your leaders to put this question to the government and pressure them to make this declaration. But also, you can join, as Meredith, as Sophia said, the African Court Coalition, which is an organization that pushes for the effectiveness and accessibility of the African Court. You can also join Amnesty South Africa. For you, Jameson, for example, if you are based in South Africa, Amnesty South Africa is a national organization based in South Africa that is running a campaign that seeks to advocate for South Africa to make that declaration. We also have national chapters or sections across Africa, in Ghana, in Benin, in Cote d'Ivoire, in Senegal, in Morocco, in Algeria, in Tunisia, offices across the continent that you can actually join and become an individual member of Amnesty International in those sections. And then you can join the promotion and the campaign to make your country either to ratify the African Court Protocol, or if they have already done so, to make the declaration. There is also someone who asked whether Malawi has made the declaration. Yes, Malawi has made the declaration, and therefore you as an individual or a civil society, if you meet the admissibility requirements, which includes first litigating the case at the domestic level, then you can actually access the court directly by filing a case there. But also, as Meredith has said, a longer route of accessing the court is filing the case before the African Commission on Human and People's Rights, the Banjul Commission, and then if they deem it fit, then they can transfer it to the African Court. And that is how, for instance, the Ogiek case, the Kenyan case, was filed at the court by the African Commission on Human and People's Rights. We are 10 minutes over the time dedicated to this event. So if you allow me, I would like to bring it to a conclusion and thank all of you, the participants that have joined us this afternoon, our call to you is one or two, that if your country is among the 21 countries that have not ratified the treaty, then you need to join with others or civil society to actually demand that your country ratifies the African Court Protocol. And if you may allow me, let me read to you those countries that have not ratified the African Court Protocol. That's Angola, Botswana, Cape Verde, Central African Republic, Djibouti, Egypt, Equatorial Guinea, Eritrea, Eswatini, Ethiopia, Guinea, Liberia, Namibia, Morocco, Sao Tome and Principe, Seychelles, Sierra Leone, Somalia, South Sudan, Sudan, and Zimbabwe. And some of these countries, as Meredith said, they have been visited by the African Court, and they have actually pledged or committed to consider the issue and maybe make the ratification. And then if your country has ratified the African Court Protocol, for instance, South Africa or Kenya, and other countries across the continent, then our call to you is that then you need to demand that your country makes the declaration that will allow you and civil society and other individuals to directly access the African Court on Human and People's Rights. We hope that this event has provided some overview and some knowledge on the existence, on the way the African Court works and how you can access, but more importantly, how you can work domestic level to ensure that your state either ratifies or makes the declaration. We are very grateful for your presence, and I want to thank the panelists, Sophia, Dr. Zainab, and Meredith, for your time, for your reflections, and for your knowledge. Thank you so much. On behalf of the Center for Human Rights at the University of Pretoria, the Coalition for an Effective African Court on Human and People's Rights, and on behalf of Amnesty International, thank you so much. We hope to see you in some future webinar of this kind. Thank you, and have a nice evening wherever you are.
Thank you too, and thank you to the participants as well, and to my colleagues. Thank you.
Thank you, Japhet. Thank you, Sophia. Thank you, Meredith.
Thank you.
Yeah, thanks everyone.